the email from Jane Wilson to Betsy Rogers? Manley called, shred my report. It was all based upon Josh Powell's lies. Well, their own expert, Mark Gates, said, these risk factors show there's a risk of suicide and homicide. It may be a small risk, but that doesn't mean it's not a risk. Their own DV guy talks about this is a significant co-occurrence. Child abuse and domestic violence. This is absolutely foreseeable. The state did foresee it. They did create a policy to deal with it. The boys were starting to remember. There was a sign. What did John Long say? It is well recognized that in DV situations, in criminal law situations, if there's somebody out there who knows what you did wrong, the risk of retaliation goes up. Josh Powell was showing paranoia. Mark Pete says that's one of the things you look for danger. He treated the kids as possessions. He exerted unusual control over them. All standard signs that there's a potential problem. This was absolutely foreseeable. Their next excuse, well, the GAL agreed with the move. Well, in a familiar situation, ladies and gentlemen, what did Julio Serrano actually testify to? Well, they didn't tell me any of this stuff. They didn't tell me that they felt he was an abduction risk. They didn't tell me that he was violating the court orders at virtually every visitation. They didn't tell me about law enforcement's concerns. They didn't tell me about Jennifer Graves' information to Rocky Stevenson. All that stuff would have been important to me. Why? Because his job is to look out for the kids. So with regard to law enforcement, ladies and gentlemen, the state seems to be saying that law enforcement's lying, that they didn't actually tell them that they were concerned about the boys' safety, that Josh Powell might hurt them. And I need go no further than Mark Gates' statement. Will you take some things with a grain of salt? Who here has a motivation to say something like that didn't happen? It's the state's actors. Who here does not have a dog in the fight? Law enforcement. I leave it to you to decide who's telling the truth about that. Next excuse. Well, it's just an allegation. We didn't have any proof that he actually killed his wife or caused her disappearance. But you heard witness after witness get up here from the state and say, all the stuff that we investigate is allegation. There wasn't any proof the boys had been actually exposed to child porn. There was no proof that there was potential sexual assault out there. There was no proof of any of the things that were in that allegation list. But they still had the obligation to investigate and make sure that they understood what the parameters were around those allegations as it affected the safety of the children. You can't carve out the overriding allegation and say we couldn't investigate that for no proof without saying we really didn't have anything to do at all with regard to any of the allegations. And of course we know that's not right. Your next excuse, well, there was really no information to gather. There's only one problem with that, ladies and gentlemen. They had lots of stuff they could look back into. Remember the original 4 intakes? Caregivers who were concerned enough about what the boys were saying that they called in and said, hey, you guys better look at this. They're threatening to kill kids. They're doing things that little kids don't do. They're saying things about their mom. Did Rocky Stevenson testify? He went out and checked into those people, asked them more details. Remember one of those intakes said that the principal has kept a list of all these strange things that Charlie's been saying. So we went out to get the list to talk to the principal. Maxwell say, I suspect pretty much everybody in the Western Hemisphere had heard about this case. It was in the media constantly. There were people being interviewed all the time who knew the Powells, who knew the relationship, who knew the coercive economic control, who knew the risks that they had seen. All you have to do is call them. And what did Park Dietz say? You can't rely on the media interpretation, you should call them. Of course they should call them. That's what is mandated in your policy. Get as much information as you can to figure out what the risks are to the kids. That was Rocky Stevenson's job. He didn't do it. No supervisor from the agency ever came to Rocky Stevenson and said, why didn't you do this? Why are you not following up? Why are you not following our policies? Their next excuse, ladies and gentlemen, is, well, we couldn't do any investigation because if we found information, we would have to put it in a report and Josh Powell would find out about it and that might jeopardize the criminal investigation. There's only one problem with that, is the lead detective for the criminal investigation testified, I never told him that you can't go out and talk to these people. Their knowledge about these people was already out in the public. And if that was true, and not just an excuse, as plainly was, if that was true, why didn't the state tell the court about the things that Josh Powell already knew about, like they found Mommy's body in the desert, which happened to the visitation where Josh Powell was? If that was going to undermine something, Josh Powell already knew. The reason that they didn't do this, folks, is because he just didn't care. Just another excuse. So who did they interview? Well, they interviewed Chuck Cox, interviewed Jennifer Graves. They both warned them, gave them information about domestic violence, about economic coercion, about the things that they were supposed to be looking out for, and their information was ignored. What did they get otherwise? Well, they had volunteer collateral people. They had Nancy LeMay, who painted a very, very different picture of Josh Powell's parent, what the state was seeing in visitation. Boing, here's your red flag. Did they follow up on it? No. They ignored her. Basically, ladies and gentlemen, the evidence shows that the state simply trusted Josh Powell when he told them things about his history, about his background, about what had happened with his family. They trusted him, notwithstanding the fact that the very professional that they hired to evaluate him for his parenting skills told them unequivocally that he was not truthful. And they closed their investigation with that paucity of information, knowing that seminal, potentially back-breaking evidence, the incest images from the wrongful. So, ladies and gentlemen, Rocky Stevenson told us this is the way their investigations go. This is standard operating procedure. And Joan Rycroft has been hired 28 times. Now, I anticipate, folks, I don't pretend to guess all of it, but I'm anticipating the state is going to say in closing, boy, we did a lot. Look at all these emails that were sent. Look at all these telephone calls, contacts with law enforcement. We went to the hearings. We checked the boxes in these forms. But if you look closely at those activities, there's a word for that. We call it busy work. Push in the paper. None of the things that the state did actually accomplished what their policies required, and that was a thorough investigation and assessment of the risks that those boys faced. They did what they needed to do to let the reunification train rumble down the track. You know what I think the state will not talk about, ladies and gentlemen, is their policies. I think they're not going to get in front of you and say, this is what our policy says, and we abided by it, for reasons that I'm going to talk about in just a minute. The truth, ladies and gentlemen, is that everything that's happened since this has been a cover-up. The state was caught having not followed its own policies, having ignored specific warnings, having not taken the precautions that it should have taken, having not put the children's safety first, Evan, let's look at slide 32. We can pull this up. You saw this with Forrest Jacobson's testimony. Next slide. Forrest was responding to Paul Smith, who she described as some supervisor at the agency. I can't remember exactly what she said. Just take a moment and read through this, folks. She was asked to explain her thoughts on the decision to move the visits to Josh's home. She talks about the agitation at FCRN, which Elizabeth Griffin Hall, who was actually at the FCRN visitation, said, no, that never happened. She talks about Josh bringing complicated projects to prepare meals, and that there was extended overtime goodbyes. Well, those are all issues that the department is supposed to stay in check on. That's Josh Powell misbehaving. Why would that be a reason to put it at his house? To reward him for doing what he's not supposed to do? The idea that the new home removed the threat identified in the dependency petition. Well, that's not what the state workers told you, folks. They told you that the risks had not been alleviated. The risks that originally sat out there that caused them to be concerned about the boys were still in play. Whether or not Josh Powell was involved in the porn, whether there had been sexual abuse. The overriding issue, was he responsible for his wife's homicide? None of those had gone away. I had a conversation with Elizabeth about her comfort level in doing them at the house, and she did indicate that she felt as though it would be better and inform me after the first visit. Ladies and gentlemen, what is missing from this email? What is missing is this line. We followed our policies. This kind of thing was so unforeseeable that it couldn't have been avoided. That would have been the appropriate answer if they had done things the way they wanted to. This is all just creating an excuse for doing something that was against their policy. And what did Betsy Rogers say in response to this? Thanks. I also like the piece you also mentioned to me that for this father, there were no major mental health diagnoses, as noted by Dr. Manley, that would have supported not having visits in the home. Nowhere, including all the way up to the level of the supervisor, do they mention anything about their policies and what the visitation policy required, what the DV policy required. Folks, this is coming up with excuses for failure. Now, ladies and gentlemen, you were shown a series of red flags in Jane Raymond's testimony. We're not going to go through them all. I touched on a whole bunch of them without describing them specifically as red flags already today. But just as we take a look here, Susan's disappearance, the boys are placed in custody, visits are moved to Josh's home, Josh murders the boys. As this process went on, the state was provided more and more and more reason to be concerned about the safety of these boys. And as it got closer to February 1 and the court's hearing, ladies and gentlemen, that risk simply exploded. The state took no action. He lost Tim Atkins. He wasn't going to get his boys back. He had to do the psychosexual. He had to do the polygraph that he was so concerned about. So we can graph what happened, ladies and gentlemen, remembering that the state's obligation, its primary obligation, is the safety of the children. And I think this pretty much tells you exactly what happened in this case. Give you just a moment to pull it up here. If we graph this out, folks, your vertical axis is the level of security. You can see the highest level of security is the DSHS office, which incidentally is what the parenting plan or the visitation plan called for visitation. Or other pre-approved DCFS facility, so the equivalent of a DSHS office. What's the next safest place? Well, FCRN, where several of the visitations took place, where they had the key fob and the alarm and doors that locked and those kinds of things. What's the next lower level? The Atkins home. Tim Atkins, you heard his testimony, took it upon himself to be more cautious than the state's agent, Elizabeth Griffin Hall. He actually went out and met the car when it came into the driveway to make sure that he was in control of the kids. He did things that the state's own agent did not. What was the place that had the least protection? Josh Powell's home. And what about the level of risk? At the beginning, there was child porn, potential sexual assault, being a person of interest, the overriding one. But then the state learned of the boy's statements. It learned of this incest images. It learned that he was going to have to undergo a psychosexual evaluation and polygraph. Ladies and gentlemen, as the red line is shooting through the roof, what is happening to the level of safety of the visitations? It's falling to the lowest level. That is not abiding by your duty. This is a case about negligence, ladies and gentlemen. Negligence, you will see in the instructions, is a failure to act as a reasonable person would under the circumstances. And what would a reasonable person do under these circumstances? Well, you take precaution. You'd follow your policies. You'd follow your guidelines. You would do a DV assessment. You would do a safety assessment. You would do a risk assessment. You would follow the therapist's advice about who should be overseeing the visitations. The state's expert, Mark Dietz, agreed. Follow your policies. That's what you're supposed to do. Dietz and Raymond both said, investigate the risk factors that you're aware of. Dietz said, follow the court orders. Dietz said, err on the side of caution. Raymond said the same thing. Of course, that's what a reasonable person does when they have care and custody of two helpless little boys. The state failed to act in a reasonable fashion, ladies and gentlemen. They failed to follow their own policies. They failed to follow the standard of care of the industry. You will see in the jury instructions that failing to follow a policy is evidence of negligence. Well, here it's overwhelming evidence of negligence because the policy existed to accomplish the goal of the safety of the boys, and they didn't follow it. The result was the tragedy that we are here talking about. There are a couple of instructions, ladies and gentlemen, that I want to particularly draw your attention to. Jury instruction number 13 talks about the duty. And it says, in this case, the state had a duty to exercise reasonable care for Charlie and Braden Powell when they were under its care, custody, and control. What does it say about the duty to exercise reasonable care? It extends to risks that are foreseeable. The foreseeability of the risk of harm is not limited to the actual harm suffered. They don't have to foresee that he's going to hatchet, douse, and burn his children. But rather it is determined by whether the actual harm fell within the general field of danger which should have been anticipated. In other words, the general field of danger that is identified in the state's own policies. I'd also like to point your attention to instruction number 17, ladies and gentlemen. This is our burden. We're the plaintiffs in this case. We have the obligation of proving negligence by a preponderance of the evidence. In other words, that it's more likely than not that the state was negligent. But one of the elements of it is that the state's action proximately caused the injuries to Charlie and Braden. What does number 17 say? It says the term proximate cause means a cause which in direct sequence produces the injury complained of and without which such injury would not have happened. Without which such injury would not have happened. The next instruction, ladies and gentlemen, number 18, talks about the fact that there can be more than one proximate cause. In other words, many different things can come together to cause one injury. All you have to do is prove that one of them was caused by the person who is being held liable, in this case, the state. The fact that Josh Powell may also be a proximate cause is not relevant. What is relevant is whether the state proximately caused the injury to these boys. And that's laid out in the next instruction, ladies and gentlemen, number 19. In calculating the damage award, you must not include any damages that were caused by the acts of Joshua Powell and not proximately caused by the negligence of the defendant. What that instruction is telling us is what we know to be common sense in order to make sure that victims are compensated for what they've gone through. You distinguish Josh Powell's actions only if his actions were not, or if the damage caused by them was not also proximately caused by the state's failure. And that is the key to the negligence assessment. If the state had followed its policies, its guidelines, common sense, investigated, had visitations where it was supposed to have them, none of this would have happened. It was in direct sequence that these boys were allowed to be given to their father in an unsecured facility where he could do the awful things that he did. So I'm going to close, ladies and gentlemen, with a little bit of a discussion of the impact of this negligence. And let's put slide 37 up. This was a beautiful family. Susan's out there someplace. Long gone. But her boys were still there. And these parents, these grandparents, stepped in. Chuck and Judy took the reins that were left when their daughter disappeared. Let's show the next picture. It's no small task. You've got two rambunctious little boys running around. But what did Paula Strickland say? Paula Strickland loves the Coxes. She talked about how hard they worked, about how attentive they were, how they worked with her to make sure that things would go as well as possible. These boys, ladies and gentlemen, their last moments, as we talked about, and you heard from the forensic experts, they were awful. They were absolutely awful. The brutality, the panic, and as I mentioned in opening, folks, the betrayal of your father doing this. I can't even begin to imagine what must have been going through those boys' minds as they saw that hatchet come out and they felt those blows and that gas was poured on them. A little boy's mind. What is going on? Swallowing gasoline, the utter terror of it. Let's play the 911 call. Ladies and gentlemen, that visitation occurred with the supervisor recognizing that Wednesday's hearing was a big deal. It was a big new risk. And what they do to prepare for it? She doesn't even know the address. There was no safety plan. There was no effort to stay with the boys so she could intervene. There was nothing done to protect them. And somewhere between that call and the next call, where she reported that the house was on fire, these two beautiful little boys choked and seared and eventually died in that house. Ladies and gentlemen, you heard Dr. Weck talk about how long this may have taken, how long they might have been conscious. You're going to be the final arbiters of what went on. But we do know something about the timeline. From the CAD call, so the next slide. The first call came in at 12:08. At 12:12, as you heard from stipulation when this was first played, at about 4 minutes and 15 seconds into that call you just heard, Elizabeth Griffin Hall told the operator that the boys had been in the home about 10 minutes. That means the boys went into the house, presumably around 12:02. Let's go to the next. At 12:15, the first 911 call ends. We know at this point the boys have been doused in gasoline, but there's no fire. What's going on? At 12:24, Elizabeth Griffin Hall makes the second 911 call. The house has just caught on fire. We know the boys are still alive because they died of carbon monoxide poisoning with soot in their windpipes. It's 21 minutes and 44 seconds. If Elizabeth Griffin Hall is accurate in her estimates. We know that they were conscious for some time because, ladies and gentlemen, they swallowed gasoline. It was in their gastric content. It was in their blood. It made its way all the way to the vitreous of the eyeball. The forensic experts all agreed you can't swallow when you're unconscious. Now, Dr. Nelson, the state's expert, said, well, it must have gotten in some other way because it wasn't in the urine. But ladies and gentlemen, if you look at the toxicology reports, what will you find? The urine was never tested for alcohol. Dr. Nelson is flat wrong. I suggest you pay attention to the actual ME who did the autopsy and told you most likely this got in their system by swallowing. I suggest you listen to Dr. Weck, who agrees with the ME's conclusions on it. That slow curtain, ladies and gentlemen, of consciousness, we know it overcame the voice at some point. And only you can decide when, thank God, they finally hit a level of unconsciousness where the pain went away. Ladies and gentlemen, I suggested an opening that an award of $5 million a minute for the pain the boys suffered would be appropriate. Because I can't imagine what it would be like to be in that position. Unfortunately, the only way that we can render justice in a situation like this is through the awarding of money. Money damages are the only choice. And so I put it to you this way. We consider what the obligations of the state were. We consider what options they had available. We consider what they recognized the risks to be. We consider what they actually did. And we consider the result. This incredible, miserable end. I don't think I'm too far off on the value. But it's up to you. It's up to you to decide what that number needs to be and how many minutes. The only way, I will tell you though, ladies and gentlemen, to hold the state accountable for its negligence in this case, for that remarkable indifference, is to compensate these boys for every second of suffering that they went through. The state has to follow the policies and guidelines that it recognizes are necessary. That is what justice demands in this case. The state's going to get up here and they're going to say it wasn't our fault, it was Josh Powell's fault. But Josh Powell would have never had an opportunity to strike those boys down, to douse them with gasoline and burn them alive, if they hadn't been turned over to him in an environment that he had exclusive control over, contrary to the state's own policies. Ladies and gentlemen, the cruel reality of it is because the state simply failed to follow its policies and put the boys in this position now. Chuck and Judy Cox look at pictures of their grandsons instead of seeing them on their laps, pictures that have exhibit numbers on them. Just contemplate that for a moment. There are certain questions the state simply will not be able to answer, ladies and gentlemen. I'm going to put the challenge out right now. Why was no collateral investigation done when the policy specifically required it? Why recognize and develop a policy to address significant co-occurrence between domestic violence and child abuse and killing, and then utterly ignore it? Why, if you followed policy, did you have to scramble to come up with an excuse for why the visitations were taking place at a location that could not ensure the safety of the boys? And frankly, the most important one, ladies and gentlemen, why was visitation moved when it was contrary to policy and the risks to the boys were increasing by the week? The state does not have answers for those questions, ladies and gentlemen. Thank you. You have been an incredibly dedicated jury. I don't know that the state of Washington has experienced something as unusual as what you've gone through, but to come back and finish this job means everything to the Coxes. We appreciate it immensely. I leave it to your good faith, to your memory of the facts, to your assessment of the law, to determine what to do. But mostly, ladies and gentlemen, I leave it to your sense of justice. These boys had a chance to grow up. They had the right to grow up, not to die like that. Thank you very much.
Thank you, Mr. Buck. We'll wipe down the podium and we'll do our podium stretch.